I would suggest to start our today's event. This is such an important point, and finally we got there. This is our 8th International Forum called Mediation and Law. So it is such a big responsibility for us, and we want to start from such an important activity as a discussion on ethics, and that thanks to our cooperation with IMI, International Mediation Institute. They're going to have a dedicated workshop on this topic. For us, this is a big pleasure to have this ongoing cooperation with IMI. They have become our reliable partners, and they take care of the mediation development internationally. They've been investing so much effort into building mediation standards, quality assurance, as well as neutrality. They contribute a lot to the development of this domain, and they build innovative understanding of this topic. It is my pleasure to give the floor to our moderator in the first panel discussion, Mr. Zachary, Calo, who is a professor at Hamad bin Khalifa University in Qatar, and he is a co-founder and an international mediator. There are a lot of credentials that you can read more about in our agenda today. Zachary, the floor is yours.
Thank you very much, and good afternoon from Geneva, Switzerland. And I know that we have people joining us from all around the world. So good morning and good evening as appropriate. And welcome to the panel on mediation ethics, sponsored by the IMI, the International Mediation Institute. Let me just briefly, for a moment, introduce the structure of our time together. We have about 90 minutes. And we're going to really do this in a couple of different parts. What we will do initially here is introduce both the concept and the importance of thinking about ethics and guidelines as they apply to mediation, mediators, and the mediation process, and then to talk specifically about the work which the IMI Ethics Committee has been pursuing over the course of a number of years to revise its general principles. So with that in mind, let me introduce our first two speakers who will discuss those issues. First, we will have Tat Lim, a very distinguished mediator based in sorry, I'm getting strange pop-ups asking me to confirm that I speak Ukrainian, which in fact I do not. There we go. I'd like to introduce Tat Lim, who's a very distinguished mediator joining us from Singapore. He is also a member of the IMI Board of Directors. He's going to be speaking about the importance of mediation ethics and the role that IMI has in this field. Tat will speak for about 10 minutes. And then after Tat, Omer Shapira will take the floor. Omer is a professor of law and a mediator based in Israel, and he has also been the chair of the committee's work and done immense labor to get us to this point. And so I want to just take a moment to thank Omer for his leadership in this process. But with that in mind, let me turn things over to Tat and then Omer, and then I think we'll come back to me and I'll explain where we go from there. So thank you very much. Tat, the floor is yours.
Thank you, Zachary, and hello to everyone. Greetings from Singapore. It is evening here, certainly not as late as some of my fellow panel members, especially Mary, and maybe not as early as some of you who might be coming in or tuning in from some other parts of the world. It is my pleasure today to say a few words about the work of the International Mediation Institute, and then also introduce Omer Shapira, who will lead and introduce the work of the IMI Ethics Committee. So let me first of all introduce the International Mediation Institute, the IMI, which is based in the Netherlands. IMI is the only international standard-setting body for mediation. IMI aims to promote transparency and high competency standards in mediation practice worldwide. IMI certifies mediators and mediation advocates to assure quality and professionalism in the field of mediation. Its certification is acknowledged and recognized by courts and various private dispute resolution bodies around the world, and allows certified mediators and certified mediation advocates to offer their services to international clients with that recognition. This evening's workshop and discussion is entitled Ethical Guidelines in the Professional Activity of a Mediator. It is a very apt title in the current age that we live in. This is what the Chief Justice of Singapore, Sundaresh Menon, Chief Justice Sundaresh Menon, has termed as the golden age of mediation. And certainly in the light of the Singapore Convention on Mediation, the issues relating to mediation ethics have never been more relevant and important. And so it is in that light that I want to now take the opportunity to introduce Dr. Omer Shapira, who will introduce the work of the IMI Ethics Committee, as well as outline of the IMI Draft Code and general principles. Let me introduce Dr. Omer Shapira. He is a senior lecturer at the Faculty of Law, Ono Academic College in Israel, and a mediator. He teaches courses and seminars on law, ADR, mediation and mediation ethics at both undergraduate and postgraduate levels, and lectures on mediation ethics in mediator training courses, professional conferences, and continuing education programs for mediators. He's the author of a few seminal books on the subject matter: A Theory of Mediators' Ethics, Foundations, Rationale and Application, published by Cambridge University Press; Use of Power and Influence in Mediation, Practice and Applied Ethics, published by the Ono Academic College Press; and Mediation Ethics, Codes of Ethics and Dealing with Dilemma, published by the Hebrew University Magnus Press. Dr. Shapira sits on a Mediator Ethics Committee initial that receives ethical inquiries from practitioners and drafts reasoned ethical opinions that are informed by the theoretical work in which he engages. He also chairs the IMI Ethics Committee, and it's my pleasure and privilege to now welcome Dr. Shapira, who will speak to us about the IMI codes and guidelines. Omer.
Thank you very much, Tat, for this kind introduction. Let me share with you a presentation that I've prepared for you, in the hope that it will make my presentation clearer. And I hope that you can see now this presentation. Yeah, so my purpose here is to, as Tat said, just to give you a brief introduction of our work in IMI's Ethics Committee and a glimpse of the draft code of ethics for mediators that we have been working on for several years. And let me start by telling you a little bit about the Ethics Committee itself. The Ethics Committee itself is made of 12 members who come from 9 countries: United States, Australia, Singapore, South Africa, Kenya, Lithuania, Serbia, Italy, and Israel. Right? It is made of people from, who are lawyers, who are experienced mediators, who are law professors. I think we are equally divided, more or less, men and women. So the composition of the Ethics Committee is quite diversified, with the aim of bringing ethics, or bringing into ethics and mediated ethics different perspectives. Right? Our aim, our goal, our tasks, Ethics Committee, have been set by the board of directors several years ago. One has been, or still is, to re-examine, update IMI's Code of Ethics. Another one is to collaborate with other institutions in the provision of knowledge about mediation ethics through seminars and conferences, and that's something that we are doing here today, and we are happy, very happy of the invitation to do that. Let me tell you a little bit about that work that we've been doing in the last 3 years. We have put many, many hours into that issue of looking into the current code of ethics of IMI and bringing it into the best position that we can. And we think that there is a lot to be done in order to make ethics more clear, more precise, more helpful for mediators. And we have been reviewing many, many codes of ethics from different parts of the world. In order to do that, we were informed by theories about mediation ethics, and we were building, obviously, on IMI's current code of ethics. We had a group discussion of each and every provision of the code. Then we put it into a process of public consultation that took several months. And we have come up with a final draft that we are very happy to share some of its insights with you. And the goals of the code of ethics, like the goals of many other codes of ethics, is to guide mediators, is to inform users of mediation, and very importantly, to instill public confidence in mediation as a process and profession. If we believe that ethical mediation is professional mediation, is quality mediation, right? So the current IMI code still holds. If you look at the IMI site, you still find it, but the new code, draft, reflects our considered view of the ethical expectations of mediators, and we are going to be informed by that draft in answering ethical questions and in interpreting the current IMI code. And what we would try to do today, for example, is to show you how we can use the principles and the concept of the code in order to deal with real issues that come up in mediation. It's important to clarify that the draft code is not intended to create legal liability of mediators. It's not aimed to punish mediators or to issue sanctions. It is meant primarily to raise awareness of mediators to mediation ethics, to give them tools to make ethical decisions, and to build and to practice a quality mediation for the benefit of the practice of mediation and of users of mediation. So let me say a few words about the structure of the draft code. It's a detailed code. It's a comprehensive code, and it tries very much to be very clear and very precise. So it has an introduction that includes sections about the purpose and liability and interpretation. It has a summary of the general principles. It is made then of general principles, as you'll see in a moment, 12 principles of ethics, of mediation ethics. And then it is followed by practice rules that take the principles and apply them to the different stages of mediation. Before the mediation, when you take a case, during the mediation, after the mediation, etc. So here's a kind of a general view of the ethical principles of the code. You can see here some principles that definitely ring very to you: party self-determination, impartiality, conflicts of interest, confidentiality, competence, and some which might seem more new to you, maybe. For example, human dignity, honesty, public standing of the profession, professional integrity. It's very important to stress that all these principles are found in many, many other codes of ethics. What we've done is just setting them in a very precise way, in a very clear way, so to make it more useful for mediation users, for mediation for mediators. So these ethical principles that we'll have a chance to even go and have a glimpse into the content when we analyze the scenario are followed by practice rules, right? The practice rules apply the principles to the stages of mediation. So before the mediation begins, you have different rules that help you understand what is expected of you at that stage. So you have to be competent, you have to inquire about your impartiality, you have to make a disclosure of conflicts of interest, you provide certain information to the parties, and then the rules clarify what kind of information you supply to the parties, etc. And then during the conduct of mediation, right, what do you do then, right? So there are issues, ethical issues that relate to voluntariness, to pressure, to power imbalances, right? What do you do then? Informed decision-making, what is your responsibility as a mediator then? Impartiality, how do you maintain impartiality even when you intervene? All of these are rules that are trying to be very practical. There are practice rules, practical. They are involved in the practice of the mediation, and they try to make them clear to the audience, to the mediator, as to what they can do in order to maintain an ethical practice, right? A third rule deals with the situation of postponing or terminating the mediation. When do you terminate the mediation? For example, for party incapacity or lack of information or partiality, right? So all these are grouped together again, so the mediator can easily consult the code and find out some possible courses of action, right? And we also have a rule that discusses ethical guidance after the mediation with respect to conflicts of interest and confidentiality after the mediation, etc. So that's a very quick glimpse, and I can also show you here. We'll go into that a little bit more in detail maybe later, but you see here an example of an ethical principle and the way it is structured. So for example, party self-determination. We made it a principle, right, or a guiding principle, always to explain, to define the terms, the concepts that we are using in order for them not to be abstract. So you can see here, for example, that self-determination is made of party capacity, of voluntary decision-making, and of informed decision-making. And then, as I said, these ethical principles, the 12 of them, are followed by practice rules. And the practice rules apply these principles. So, for example, when you assess party capacity and you verify if you can participate or not and decide whether you can continue or not, you are doing that by applying the principle of self-determination. And there are other examples for that as well. It's important for me also to stress that what the code is not. And the code doesn't tell, and I think that no ethical code should tell mediators how to conduct the mediation, what techniques to be used, or what style of mediation to use, right? Ethics is accepting the variety and diversity of mediation ethics. So you may use separate meetings or not. You may use mediator proposals or not. And you may be a transformative mediator or problem-solving mediator. The important thing is that you do that ethically, that you do that in accordance with these principles: fairness, respecting public self-determination, etc. Also, the code doesn't, limit your creativity, and it doesn't require you also, and that's another point, what is impossible, right? Sometimes some codes, I think, may be read as setting standards which are for angels and not for mediators. And this is not our wish here. We want to, and we think that mediation ethics is for mediators who are flesh and blood, who are asked to work in a reasonable way or in accordance to reasonable expectations, and not something we cannot ask them for things which are impossible. So it is grounded in practice, and it attempts to do that. Right? So I'm not going to look at these, where there are different principles of the drafts code that we are going to use later on in our dealing with a scenario. So I'll stop in that and hand over the floor to Zachary to continue.
Wonderful. Thank you, Tat, and thank you, Omer, for getting us going. So here's the plan for the next hour. I'm going to offer some introductory thoughts on the concept of neutrality within mediation. And from there, we're going to move to looking at a hypothetical, a problem that we can analyze. And this is going to be done by my colleague, Dorcas Quek Anderson, who is a professor at SMU, Singapore Management University, and also a mediator. And she's going to present this hypothetical as a way for us to kind of see how these principles actually work and are stretched when they actually have to confront reality. Anybody who has, for instance, studied law recognizes that there's a gulf between the words on a page and how one has to understand and apply principles in practice in complicated, often perhaps ambiguous situations. And Dorcas has developed a very interesting problem to help us think about both the meaning and the limits and the application of these principles. As Omer mentioned, the code was not drafted for angels. It was drafted for the real world. And I think Dorcas will help us to think about how one works through that process. From there, Dorcas is also going to introduce some other concepts that bear on thinking through mediation ethics, notions of dignity, the public standing of the profession, fairness. So some other concepts that we think are also important to think about. And then from there, Mary Walker will take over. Mary is a barrister, a mediator, arbitrator based in Australia, where she's been a leading figure both in Australia but also internationally in dispute resolution for many decades. And Mary is going to introduce some issues, let's call them new issues, new trends that are emerging in different jurisdictions as it bears on questions of mediation ethics, the regulation of the profession, indeed the legal status of mediation as a profession. So some other considerations that we think are important for this topic. And then we'll hopefully leave some time at the end, which is scheduled. We're scheduled to conclude about 2:30. So we'll hope to leave some time at the end for Q&A and engagement with the audience. So let me take a few moments and talk in some detail about the notion of neutrality in mediation. Something you may have noticed is neutrality did not appear on that screen Omer posted with the 12 principles. And I think this is quite interesting and revealing, because one might well posit that neutrality is certainly one of, perhaps the most foundational principle in mediation. It is what makes mediation mediation. It's a concept that runs through so much of the process. And indeed, we can see that neutrality is not so much a standalone principle, though it certainly can be that, but it is something which is illuminated by, and which also in turn illuminates many of the principles that Omer listed. So what I want to do is talk about, let's say, three modes of neutrality. That is, three aspects of how we understand neutrality. that also have some resonance and grounding in the IMI guidelines. And these three notions would be neutrality and impartiality, neutrality and self-determination, and neutrality and professional integrity. We might actually, I mean, it might even be more apt to use the following formulation to refer to it as neutrality as impartiality, neutrality as self-determination, and neutrality as professional integrity, emphasizing this idea that neutrality, although on some very basic level, I think anybody who has been engaged in mediation has a visceral understanding of what neutrality entails, that the mediator has no stake in the outcome, that the mediator is not a decision maker, the mediator is not pushing a particular outcome or seeking to effectuate a quote unquote just outcome, but is neutral. And yet neutrality, we can begin to see, is actually composed of a range of different pillars, if you will, different modes of neutrality. And what I want to do in the next few minutes is just talk about what those different forms or formulations of neutrality, all of which again have resonance in the IMI guidelines, are. And then I think we can, when Dorcas will take over, we'll see how to apply these notions and also to see where they run into ethical challenges, because these are not easy black and white principles, and no code of ethics can encompass the full range of possibilities that can encounter. The best we can really do is to inhabit a normative framework and then think through particular applications. So the first one, this notion of neutrality as impartiality. Let me here mention a general principle from the IMI guidelines. This is guideline number 3.1, which defines impartiality as freedom from manifestation of favoritism or bias. I mean, that's the gist of 3.1. Impartiality is freedom from the manifestation of favoritism or bias. And it is not just manifestation in the sense of actions that might constitute favoritism or bias, but also actions or behaviors which might give the appearance of favoritism or bias. Now, this aspect of neutrality as impartiality, I think we can then kind of push these definitions together and see it as concerning freedom from bias, right? And that bias is said to arise when a mediator holds or develops or manifests an actual or apparent preference for one party or preference for a particular outcome. And so when we think about neutrality in this vein, we might say at its most basic level, it entails avoiding bias, right? That the mediator has no interest in the problem or in the terms of resolution. This seems rather straightforward, and as an articulable principle, perhaps it is, but I think it's actually very difficult because we're talking both about behaviors, but also in some sense, a mindset, a disposition by which the mediator encounters the process and encounters the parties. When I talk about this concept with my students in legal ethics, what I try to present to them is the notion of withdrawing from a mindset in which one is invested in questions of right and wrong as it pertains to the outcome, especially with respect to matters of law. We're dealing with a dispute that has at core a legal dimension. And I think what you begin to see is this is actually very difficult for lawyers. It's easy to articulate. It's actually quite difficult to inhabit because lawyers are trained to be critical, evaluative, to think about who has the best argument as a matter of law. And I think it's very easy for mediators, even unconsciously, to kind of slip into a mindset where you start to think about the arguments being presented, who is right and who is wrong. And this notion of neutrality as impartiality stands as a barrier against that kind of disposition. The second concept that we were going to mention is neutrality as self-determination. This is an interesting and I think particularly controversial understanding of neutrality. So self-determination, let's start with that concept. What does self-determination as applied to mediation mean? Well, I think we might define it, among other things, as including the idea that the mediation process, that parties we should say, parties in the mediation process have and can exercise autonomy, that they can make their own decisions about the dispute, that they are empowered to do that, right? That they have not just the abstract sense of empowerment, but the actual capacity in reality, in a particular context of a negotiation, to make an informed decision. Now, this notion of empowered self-determination begins, I think you can see, to invite certain tensions that complicate a straightforward understanding of neutrality. What does it mean to ensure or to advance self-determination among the parties when self-determination is understood to entail informed decision-making and empowerment? Now, let me turn for a moment to the IMI code, which I think tries to walk a very delicate balancing act between a notion of neutrality that is in some sense captured by what we just discussed, neutrality as impartiality, while also recognizing that neutrality has another side to it, another dimension, another mode, and that is when it intersects with questions of self-determination. So paragraph 3.2 in the revised guidelines makes, among other things, the following proposition: that a mediator may, and I want to linger on that word may, this is permissive. It does not require a mediator to do anything. It empowers the mediator to make a decision, to perhaps act in a certain way. So permissive. A mediator may use different types of interventions with parties when they are necessary. Okay? A word that, while of course one can argue around the margins about what constitutes necessity, it sets a fairly high threshold. Necessary to support each party's right to exercise self-determination. Okay? And there are some criteria which I'll mention in a moment, but that first sentence is the key. A mediator may use different types of interventions with parties when these are necessary to support each party's right to exercise self-determination. So the code adopts as a normative principle that mediators may, if they deem it necessary, engage in certain kinds of conduct with respect to the parties that seek to facilitate the active empowerment or the realization of self-determination on the part of parties. Now, there are some limiting principles that follow. The intervention must be the minimum necessary to ensure self-determination. The mediator must be particularly cautious to avoid any appearance of favoritism or bias. And the mediator cannot violate another ethical duty. Okay? So there are strictures, but nevertheless, the mediator is empowered to take actions to facilitate the realization of self-determination on the part of parties. Where does this arise? Well, the sort of the quintessential example of where self-determination as a problem or a challenge for neutrality often arises with notions of power imbalances between parties. What do you do if it seems one party lacks, perhaps both parties, but more often than not, this might arise in a context of an imbalance, where one party seems to lack knowledge, capacity, sophistication, a position with respect to the other party to actually negotiate in a manner that will facilitate an outcome that is fair. And I think it's important here to begin to introduce a tension that is baked into this, that we said earlier that a mediator, understood as exercising neutrality as impartiality, has no stake in justice in the sense of a just outcome as measured by an interpretation of law, some normative principle of what is equitable, etc. And yet, this notion of neutrality as self-determination does at least invite considerations about when a form of justice in the form of imbalance or lack of empowerment is of concern to the mediator, and where the mediator is authorized to take certain steps to perhaps correct that. This is, just to give you some context, I would say this is one of the most debated and complicated questions within the field of mediation ethics. At a very simplistic level, some would argue that a mediator has an affirmative obligation to do things to redress power imbalances. That is, the mediator has to adopt a strategy with respect to process, that is, to inject inequality in process in order to generate equality of outcome. There are others whom I think it's fair to say would be of the mind that authorizing the mediator to act in certain ways to facilitate empowerment is itself intrinsically problematic, that it violates a different notion of neutrality. And so there's a lot of tension around this issue. And I think what you can see is the IMI code has tried to walk a very careful and prudential line, recognizing that the question of self-determination is one of foundational concern to the effectuation of an ethical mediation process. And yet, self-determination understood as a variant or understood in light of neutrality and other notions of neutrality, as for instance, impartiality, can't be taken too far without changing the very texture of what mediation is. So this is a difficult issue. And I think the code, again, tries to strike a balance. It is permissive, right? Again, it does not require a mediator to do anything. It authorizes limited conduct under limited circumstances. The permission to intervene must be minimal. There cannot be an appearance of bias. And then, perhaps most interestingly, you cannot violate another ethical duty. Inevitably, that might invite a certain clash of norms that causes its own complications. What do you do upon the collision of two seemingly incompatible propositions? But that's a problem for another day. So just to conclude, let me mention one other provision of the code, which I think is relevant here. This is a 2.1, which provides that a mediator shall conduct the mediation based on party self-determination, and that party self-determination means that the parties act with capacity, voluntarily and voluntarily make informed decisions without coercion. So there are all kinds of questions, and Dorcas's hypothetical will, I think, invite us to reflect on what this actually means and where the challenges arise. But just to put some questions on the table without simple answers, but questions that I think warrant reflection on the part of all of us, is what does it mean to ensure that a party has capacity? What does capacity mean? Right? What is an informed decision? Right? What kind of differentiations in power matter? Right? There are often going to be power imbalances, different motivations driving the parties that place them in different positions of strength vis-a-vis each other. An employer and an employee are in different positions. There's an intrinsic, oftentimes, power imbalance there. There may well be a differentiation in sophistication, in knowledge, in that one party might be represented by counsel and another might not. Where do we draw the line about when an intervention is appropriate and what kind of intervention? These are the sorts of questions that we are invited to reflect upon. Finally, just to conclude, the third mode of neutrality is what we might call neutrality as professional integrity. And again, Dorcas's problem will really invite some interesting considerations here. The relevant provision of the IMI code here is 8.1, which provides in its initial formulation that professional integrity requires the mediator to act within the confines of the mediator's role. That's the first sentence. And this includes, most critically and relevantly to the hypothetical, that there has to be a separation of professional roles and services. The mediator as mediator is acting as mediator and not in some other professional capacity, which that mediator might have capacity in, and potentially which parties may wish the mediator to invoke in some manner. So how does this relate to neutrality? A common example that might illustrate what is going on is a mediator who is also a lawyer. Maybe a lawyer with very sophisticated and extensive experience in matters that are currently being mediated. And this rule talks about the disposition that the mediator has to adopt between the role as mediator and the other hat which that mediator might wear as counsel, engaging similar parties on similar matters. Again, like so many of these rules, put in the abstract, this is fairly straightforward. You're there to be a mediator. You're not there to be legal counsel or judge or arbiter, what have you. But we can also begin to see how very quickly these lines between acting as mediator and engaging in something on the margins becomes fuzzy, complicated, right? How far can a mediator go with respect to using legal knowledge in reality testing, in pushing a parties to think about the strength of their position? What if the parties both want the mediator to assume a strong evaluative role in the mediation process? What role is permissible under this guideline we just read? Perhaps more complicatedly, what if one party, let's make it even more difficult, a party who is lacking vis-a-vis the other party in self-determination, a party who is in a position of weakness, who doesn't have legal counsel, who maybe isn't sophisticated, who is in a position of personal vulnerability, seeks the help of the mediator in trying to understand what is going on, a request that might necessarily pull the mediator into a role outside that of mediator. Right? These are circumstances that are not abstract and unusual, but they are quite real and not at all uncommon. And so again, we need to think about how to understand this rule in light of these situations, neutrality as professional integrity. So let me now, with that introduction in place, let me turn things over to my colleague Dorcas, who is going to introduce a very interesting hypothetical which he has written that I think will push us to think about the notion of neutrality in a dense fact pattern, and walk through the application of the code to that hypothetical, and then to also think about some additional allied provisions of mediation ethics. So Dorcas, the floor is now yours.
Thank you, Zachary. Good morning, good afternoon, good evening to everyone from Singapore, where it's now at night. As Zachary has given a very detailed explanation of some of the ethical principles, what I want to do is to make some of these principles real to us by seeing how we can apply them in a situation that might confront us as mediators, right? So, and personally, I find that principles are very important because once we have more consciousness of the relevant principles, it can guide us in our decisions within mediation. So let me just share this. It's a purely fictitious scenario, and I'll just read it out, and then I hope we can follow along. And then I will give some views as to the relevant principles that can guide the mediator in the decision, and some of my colleagues from the ethics committee will also chime in with their views. Okay, so let's share this now. Yes, I trust that you can see this. Let me just read it quickly so that we have time to digest. So this is a situation, there's a dispute between alpha and beta. So Alpha, or A, is a company that created an educational software for Beta High School, B, for their students to learn English. So the school Beta complained that the software is defective. Alpha and Beta, A and B, agreed to attend a mediation conducted by Gamma, G, who is an IMI certified mediator, who is also a world-renowned expert on computer science and information technology. Both Alpha and Beta have not engaged lawyers for this mediation. Right, so this is what happens during the mediation now. During the mediation, Alpha's computer engineer gives a highly technical presentation on how the software has no defects according to industry standards. Beta High School's principal is visibly confused and asked to speak to Gamma in a private session. Okay, so this is what he tells the mediator. So Beta is a school. The principal tells the mediator that it does not know if Alpha's arguments are valid. And Beta says that they had earlier consulted only the school's computer science teacher, who concluded that the software was defective. Unfortunately, the computer science teacher is on a vacation and uncontactable during the mediation. Right, so now Beta's principal asked the mediator two questions, right? Actually, one question just broken into two parts. Okay, first, he says, we chose you as a mediator because you are confident you can help us with your expertise. Since you know so much about computer science, can you tell Alpha at the joint session whether their arguments are valid or correct? That way, Alpha can be corrected if they're making incorrect arguments. Okay, so then the mediator appeared hesitant to agree. So he followed up and said, if you're not comfortable with my earlier request, you can just tell me your opinion privately now. And don't let Alpha know you have given me advice. I will then tell Beta later that I've consulted a highly qualified expert who disagrees with their arguments. Please help, as I have no clue about what Alpha is saying. Right, so I will talk more very briefly about this first question. Okay, so there are two, you see two speech bubbles. I will talk about the first question. But just before we go on, maybe we can take a moment to think and think about, is this a difficult situation or not? And also, we have earlier shared this link to the draft IMI professional code, which really contains a lot of the principles that Zachary so comprehensively explained earlier. Right? So maybe we can take a moment to think. Does it raise any dilemma? And if it does, what are the relevant principles in the code that perhaps could be of guidance? Okay, so I will share you my take, but this is just my perspective. And the good thing about gathering of mediators is everyone has different perspectives, even though we are what is guiding us is a set of common principles, right? So it can facilitate our discussion. Okay, so moving on, as you think about your dilemma, well, maybe something that pops up, which Zachary did actually talk about. He just talked about this principle of party self-determination, right? If you recall, Dr. Shapira said there are general principles in our code, right? So this is one of the general principles. I'll just produce there the words for you, which have been translated. I think here what you notice is the second sentence, which says that party self-determination means that the parties with capacity voluntarily make informed decisions without coercion. So I think there might be some question mark in your mind as to whether Beta, right, because they did not really consult, they only consulted their colleague who's a teacher, and they don't know what Alpha is talking about during the mediation. So there's a question whether are they able to make informed decision in the course of the mediation. So that might be something that might pop up in the mediator's mind. Okay, so I'll just go through very briefly, and you can always refer the code as to what self-informed decision-making is. Okay, but one thing that pops out and also that triggered Beta's request to talk to mediators really doesn't understand he doesn't understand, how's he going to make an informed decision, right? As to what to do or whether to settle. There may be another principle that might be relevant, again, general principle. You look at the right is what Zachary has been discussing. Impartiality. So we chose the word impartiality instead of neutrality. And the key thing Zachary stressed was the main idea for impartiality is freedom from bias. Okay, and the interesting thing is also not just freedom from bias in our mind, but the appearance. That means parties must think that we are free from bias or favoritism. So it's appearance of freedom from bias. Okay, so maybe you can think, does the request by Bella to give a mediator's opinion in a joint session? In the joint session means in front of everybody, alpha, beta, everyone who's there. Does giving that opinion as to whether alpha was wrong or right, would that create an impression or appearance of bias? Just consider that. There's also a question to consider. Okay, so and let me make it even more complicated to just elaborate, right? Remember when Zachary talked about impartiality, he said that impartiality in the quote is actually discussed hand in hand with self-determination, which is what I just showed you, right? So it does not prohibit the mediator, this principle of impartiality, from intervening in certain ways, right? You have to balance it with and it doesn't prevent you from also helping people make informed decisions, right? So the question is really how to satisfy both principles, right? To help in self-determination, but maintain the appearance of freedom from bias. Okay, as I told you, I'll make it even more complicated. So I'm adding a third principle, which also was very ably discussed by Zachary. And this is professional integrity. What does that mean? This is probably a new, maybe not a very common principle in the code of conduct, which we have chosen to include in this quote. Well, again, I've given you a summary of the general principle of professional integrity, which in a nutshell, the main idea is that the mediator acts within the confine of the mediator role, rather than going out of that role. So one of the components of professional integrity, there are actually 4 components, but I specified the relevant one here, which is separation of professional role and service. And if you go further to look at paragraph 8.3.1, there is that tension, right? Because if you're a mediator, but you're also a lawyer, and in this case, Gamma is a computer science world-renowned expert. And this expertise is very relevant to the dispute between alpha and beta, right? So this question is, beta therefore seems to be obviously asking for some advice, right? For Gamma to give some advice. So the question is, if he does give advice, is he stepping outside the proper confine of a mediator role, right? And is he not doing mediation and doing something else, providing another professional service? So that's also something that have to be balanced. And so we see there are 3 relevant principles here. And I think what is actually interesting and probably unique in our quote is that apart from general principles, we wanted to make it clear how they can be applied in different stages of the mediation, which Dr. Shapira earlier explained. So if you look at practice rules, there is actually one portion that mentions all these 3 principles, which I've just shown you, in terms of how they could possibly have to be balanced during the mediation. Okay, so it's rather quite wordy here. So I just want to just look at the purple box. Effectively, this one is just saying that sometimes a person in mediation might ask the mediator to give an opinion because the person has relevant training or experience in that arena. So notice the last sentence, which is within the purple box, says that you actually have to bear in mind these 3 principles and hold them in tandem. Which is because, yes, maybe the person does need to understand, right? But can we make it clear that I'm doing it in the capacity of mediation? I'm not acting as a different kind of professional, and that I'm not primarily giving you advice here. Okay, so it's suggested that sometimes, and this is my personal view, is that sometimes if you want to make it clear to a person, right, it has to be couched. You have to remind them again what's the purpose of mediation. And if I do give an opinion, maybe not so much frame it not in so much in terms of a legal advice or opinion, but a discussion, right, which you actually see and hear. Right, maybe more like a discussion so that we go through what you need to know in order to make a decision. Then the other thing you might have to be conscious of is if Bella's request is granted and then the mediator just gives his own opinion in front of both Alpha and Bella, is that the best thing to do? So this is interesting because I'll be curious to hear some of my colleagues' viewpoints. Personally, if I do give some opinion, having made it clear that this is not advice in a different capacity, I would tend to do it more in a private session setting rather than in a joint session. But of course, if it goes beyond a mediation, right? That means we both parties agree, hey, we have come to the end of mediation. Now we want a formal evaluation. In such a context, I think I would give it when both parties consent and both parties very clear we want an evaluation, which is rather different from the main tenor of mediation. Only then probably I'll give it in the presence of both parties. But because I'm very conscious, and it has happened to me before, where I've given opinions, even very subtly in front of both parties, very quickly one party might feel alienated or feel that you are biased or favoring one party. It has happened to me so many times. So those are my 2 cents worth, and I think I'll see any other colleagues would like to add on. Let me just show you the scenario once again.
Thank you.
Omer?
Thank you very much, Dorcas. If I may, I would like to maybe make some few quick comments and maybe then pass on to another member of the panel. Right. So I would like to highlight, maybe I think that Dorcas, you've done a really good job in talking about the main points. And I would like to draw maybe some attention to other principles that are already or also might be involved here. So one is actually, I would say, fairness, right? And maybe you can move that slide to this principle of fairness, right? We are talking here in this scenario also on a situation of imbalance of powers, right, between the parties. And party B here clearly lacks knowledge and understanding. He cannot participate, I think, effectively in the process. And the codes, in this case, guides us to react, the mediator to react. So that's the very important issue, right? Don't stay passive, do something. It's not, if you keep doing nothing that it will solve itself out. Yes, there is a problem here. The issue of party self-determination, the issue of neutrality, but the expectation of you as a mediator is to do something. And one of the reasons for doing something is this principle of fairness. The principle of fairness tells the mediator that he has a certain responsibility to conduct a fair process. And a fair process is also a process that is based on the other principles, right? And about a true or a realistic principles, I would say. So if a party is not aware of information, he cannot participate in full sense in the mediation. And as a mediation, you have to do something, right? When you have to do something, then the other principles are triggered. And here, if you go back, please, to that principle of impartiality, Dorcas, I just want to stress that issue of impartiality, or we call it now neutrality as impartiality. Again, I want to say that we did not use the word neutrality as a principle, or the term as a principle, not because neutrality is not important, but because neutrality is such a complex principle and term that you actually have to break it down into the different aspects of neutrality: impartiality, conflicts of interest, professional integrity. You have to, otherwise it becomes very vague. And in fact, most of the codes of ethics that I'm aware of do not use a principle of neutrality. It's very rare. They also prefer to use different terms like impartiality and conflicts of interest to explain that. So here in this case, I just want to stress that point, that some codes and some even trainers give the impression that neutrality and impartiality are like that's the most important issue and most important guideline of a mediator. And it's true that it is very important, but the reality is that there is no and there cannot be absolute full neutrality. And that's what we've tried to show here and in the code, that sometimes you have to balance this idea of impartiality by giving some weight to, for example, self-determination, or for example, that issue of integrity, right? So the code here tells us, and what we see is that when you apply impartiality here, then the mediator is allowed here to help, I think, party B, right? But how is he allowed to help him? He cannot help him by providing the information directly himself, right? Because if he does it, he definitely digresses very drastically from this idea of impartiality or favoritism. But if, for example, he postpones the mediation, if he gives the other party some space to ask questions, some time maybe to seek other advice, maybe there is no choice here but to take a few days or even a month and then continue the mediation after that principal has a chance to discuss it with his other expert or with his other friend, right? Because he cannot continue as it is on the one hand side, and he cannot make a decision without not necessary information. So here the code, again, is not necessarily give you a straight answer what to do, but the code is giving you means for thinking about the possible interventions and the way to go through, and offering grounds. Why do you decide what to decide, right? And another point, right, or another aspect here that hasn't been discussed, right, and Dorcas left it for us, is that issue of honesty, for example, and public standing. So again, Dorcas, if you can move to that slide. So honesty, for example, is not a familiar, right? It's not often found in codes of ethics for mediators. And also the issue of public standing, which is not often used. But they are, I must say that they are all found within I think, between the lines in codes. And why I'm saying that, and if we apply to the scenario, right? So the mediator, why I think that the mediator should not agree to parties' suggestion here to advise him in private and hide it from the other party. He cannot do that because of the issue of honesty, because to do that would be to lie, to make an untrue statement. And why can't you make such, or why you should not make such a statement? Because underlying all the principles is this idea of the mediator being trustworthy. You have to be worthy of the party's trust, and you should not betray the trust, right? And if you make a kind of coalition like that with one of the parties, and if you stay, right, and you lie to one of the parties, then you are definitely acting in an untrustworthy way, and you should not do that, right? And another reason, beside this requirement to be trustworthy, another reason why we should be honest and the mediator here should not take that part in this kind of suggestion is because, and the code draws our attention to that mediation is not just a private process between the parties, which is totally controlled by the parties. There's also the idea of the mediator owing some obligations or having to consider also the effects that his actions might have on mediation as a process, on the public perception of mediation. Mediators should not be perceived as liars. Mediators should be perceived as trustworthy professionals. Otherwise, people will not be confident enough to go to mediation, to try mediation. And we mediators, right, and the code is like alerting us to this idea that we should also think about when we are taking a decision, how is this going to affect our colleagues? How is this going to affect our profession? How is this going to affect the mediation center or mediation association to which we belong, right? We have to be seen as trustworthy. We have to maintain our impartiality and neutrality, not only because we want to be worthy of the party's trust, but also we want to be worthy of the trust of the whole public that should go to mediation, try mediation, believe in mediators, etc. Right. So I stop here and please.
Dorcas, do you have anything else you'd like to add, either about this topic or other topics before we turn things over to Mary, who may also wish to comment on the hypothetical, among other things.
Yeah, nothing more to add, just to echo what Omer said about balancing several principles at the same time.
Great. Well, thank you. Thanks to both of you. Mary, why don't we move over to you now, and of course, feel free as you may wish to comment on the hypothetical or turn to any other topic of your choosing. But the floor is yours.
Thank you, Zach. It is a pleasure to be with you this evening from Australia and also with this august panel. They're not only colleagues but friends, but they are all very experienced in this area. It is our custom in Australia to acknowledge our First Nations people. I acknowledge the traditional owners of the lands from which I speak to you today, the Gadigal people of the Eora Nation, and I pay my respects to their elders past, present and emerging. I'm going to work on key issues, if I might, about what is the important mediator ethics. IMI has shown leadership in this field of mediation and the ideal of professionalism and ethics. But also the IMI Ethics Committee, as you've heard, is culturally diverse. And why is this important? It is context. Ethics and culture intermingle, and it's a challenge to develop universal or international codes which fit comfortably in various cultural contexts. So there are two touch points that I'll be speaking to you about this tonight. One is professional integrity and public standing of the profession, but also about the mediation process and from the Australian perspective and context. And I know Zach indicated that I would give you some perspectives from other jurisdictions. But when I talk about ethics, I teach it by saying leading by process. So I look and I try to have everybody look at the process itself and who's involved in the process and the expectations from the process. So when we were talking about this current scenario, I thought it was really important to say, well, look, yes, there are power imbalances, but some of them are real and some of them are perceived. Some mediator might deal with by the contract in the mediation, the agreement as to what the expectations are, by preparation from the preliminary conference saying, I'm not in a position to give you advice. Let's talk about resources and the things that Omer talked about time, space, having an opportunity to clarify issues and obtain advice. But some of the things that we've built into protecting vulnerable people in some of these processes in Australia are cooling off periods. So it may be that you have people who are not legally represented. There are complex issues, but they are determined to come to an agreement without having breaks or considering other matters. Then how do you deal with that at the end game? If they sign on the agreement, is it enforceable immediately, or can you give them a cooling off period? So there were some of the things that I would throw out to you. But also, many years ago, I was acting as a representative, an advocate, in a mediation in our federal court. And there was a mediation being held by a registrar. And the registrar said to the other party in front of us, right at the beginning of the mediation, told the other party they were going to lose. It was very difficult for us because my client actually wanted to settle the matter for a whole lot of other reasons, not just the legal outcomes, but commerciality and other matters. It took 6 months before they would come back to the table to negotiate because they lost their capacity to engage in a negotiation. So I think, often people want to cut things short in a mediation by having essentially a med-arb or being given an advice, and that cures the problem. What I would say to you, it doesn't often cure the problem, and the empowerment and the self-determination of the individuals or representatives of corporations in a mediation, I think is really essential. And coming back to Australia, we're having a debate about the whole idea of party autonomy and self-determination, because we've got a proposal for a new accreditation process, which is not being adopted universally at the moment. And one of the aspects that's been taken out is that aspect of self-determination and party autonomy. So where do we go with that? Yes, impartiality and other aspects are brought in. And I think one of the problems, because we've been in this for a very long time in Australia, at least in the journey of introduction of modern mediation, is that there's no empirical
Which mediation? I'm sorry, I couldn't hear that.
Sorry,
in Australia, you've been in the process of implementing modern mediation. What is modern mediation?
Modern
Modern,
concept.
I'm sorry.
Yeah, sorry. And one of the things that I think we don't have, and we've constantly talked about it at the Law Council of Australia, is empirical evidence or data that can be brought to bear to give us not just anecdotal ideas about what we think are good outcomes, but what is really assisting parties. So we've had some engagement by the Civil Justice Centre, which looked at the differences between litigation, arbitration, mediation, and negotiation, and the whole idea that parties who engage with self-determination, where they can impact the narrative, where they can impact the outcome in negotiation, pre-trial conferences, as in settlement conferences or mediations, their perceptions of fairness and satisfaction with the legal system is much higher than it is in arbitration or litigation. So I throw those matters out to you. But I'm going to give you a little bit of history because I know we don't have very much time. But when Australia embraced ADR, which was really, I suppose, mediation in the 1980s, but we were the first to take on arbitration way back in the early part of the 20th century. So when we engaged in mediation, we were very open to the adoption of that. And in 1990, the Supreme Court of New South Wales ran a pilot. When they did that, it was highly successful, but some of the concerns started to come about by those who engaged in it, saying, well, due to confidentiality of the mediation process, what about accountability? What is actually happening in there? Should we be able to see what's happening? Should people be able to make complaints, criticise the process? What about the behaviour behind the cloak of confidentiality? What should we do about that? So there were also this idea of ensuring greater accountability of practitioners, but also it was argued that ADR service providers had a responsibility for the standards of their practitioners. And standards may also be applied by the service providers in an objective criteria to see whether the practitioners carried the appropriate competencies in the area. So how is that going to be dealt with? So what occurred was that codes of conduct were discussed, guidelines for mediation, not only for the mediators, but the lawyers and the parties. And then there was the talk of practice standards. And one of the main aspects of all of this in our narrative was to talk about mediation, its flexibility and adaptability and party autonomy, and that making rigid processes or practice standards was really going to detract from the mediation process. So now we've had a number of different accreditation processes. You probably all have heard about the National Mediation Accreditation System, but there was also a separate one for family lawyers and family mediators. There is now another one called AMDRAS, which is taking over from the NEMAS, and I'm sorry about the acronyms, but there are criticisms of this because not only is it trying to deal with mediators, but also with dispute resolution practitioners. And dispute resolution is defined dealing with predominantly consensual processes rather than arbitration and litigation, but it's causing a great deal of confusion. So where do we go from here? I think that standing back and saying, what is a profession? One of the things that we're dealing with at the moment is mediation a profession in Australia. And people are not yet in a frame of mind to say, yes, it is. So I wanted to talk to you a little bit about what a profession is. And I went to the St. James Ethics Centre quite a long time ago now and took this from their website. In every profession, there is an implicit bargain struck with society. In return for acting to the benefit of society as a whole, professions enjoy privileges, such as an exclusive right to practice and self-regulation. Foundational to this bargain is an expectation of ethical conduct, a self-imposed requirement to think and act ethically within the profession. To this end, practitioners receive training in the rules and requirements pertinent to their field and are also given guidance by their representative bodies through codes of ethics and conduct. So we are on our journey, but are we talking about good practice or ethical obligations or both? And so when one's looking at a profession, the Australian Council of Professions defines profession as the following: a disciplined group of individuals who adhere to ethical standards and who hold themselves out as and are accepted by the public as possessing special knowledge and skills in a widely recognised body of learning, derived from research, education and training at a high level, and who are prepared to apply this knowledge and exercise these skills in the interests of others. The other aspect that we talk about in Australia is the public interest. And when we looked at the public interest and ethical behaviour in mediation, we've had cases in court defining the activity of not only advocates or representatives in mediation, but also the mediators. And some have fallen foul by drafting the agreement at the conclusion of a mediation, which was seen as tantamount advice if they were a professional, for example, a lawyer, and they missed out on including something in there rather than being a scribe. And so we've got many, many layers of what is being, I suppose, discussed at the moment in Australia about where we are with mediation. And I think that what we are now also looking at are the key indicators, the core values, as you will see with the IMI code. And they are seen as integrity, ethics, trust, and expertise, which fall within similar semantics within the IMI code. So ethical activity in a mediation affects not only the mediator, but the representatives as well as the party, as in all participants. So if I'm talking to lawyers, we talk about parties. If I'm talking in a broader context, I talk about all of the participants to mediation. And I often change my language to be slightly different to try and get the context across. But we're with a group, as I understand, we're talking with mediation and the law. And I think we need to step back and say, what are we actually dealing with about the mediator, about the organisations that refer these mediators, about the parties, and about expectations. And I think the IMI code, which deals with all of the issues that we've talked about, fairness, party self-determination, impartiality, etc., really brings that conversation to a head. But one thing that I think also brings perspective is looking at something like a med-arb. At the Law Council, we prepared a commentary on med-arb because we were worried about this idea that, oh, look, if it gets too hard, the mediator can make a decision or give advice. Where do you go with that, and what are the pitfalls, what are the difficulties? And what it did, I think, was to really start to hone in these core elements of what we would consider to be part of the mediation process and crucial, and what was not. And I think one of those, why it's important, I think, is it really does focus the idea of, well, if confidentiality is important and in a mediation you hold private sessions, and it is more, I think, focused in the common law jurisdictions, then if you move to an arbitration, what is happening with procedural fairness? In China and in Singapore, if you move to arbitration, then the mediator has to disgorge all of what's been said in the confidential caucuses, private sessions, before they can make a decision. In my jurisdiction, it might be read on to the record if it's in a court when they move from one process to another. So where do we draw the lines on this? What do we think are the most essential pieces? And that's really the conversation in Australia at the moment, but I suspect it will be a broader conversation. And I also think that we need to go back and say, ethical responsibility, what is it? And I've got a quote here that says, professionalism contains a distinct essence that transcends each discrete discipline. That essence is a type of fiduciary relationship, the ethical responsibility to benefit not only the individual clients served, but also society as a whole. Today, society includes the environment and professionals of all stripes, and they continue to grapple with balancing the interests of their clients and positive social outcomes, plus, in many cases, their own need to make a living. And then that brings in perhaps the conflicts of interest, the idea of self-benefit, if there is an issue about a success of the mediation, because in some of our class actions, we have issues that might arise in respect of the different layers of benefits to the funder, or, for example, to some of the class members or to the lawyers. Our remedy of that is to seek court approval. So what about those who are vulnerable? People who are of legal incapacity, for example, mentally challenged or may not have capacity, or are infants. What happens in those circumstances? Who oversees the outcome? Do they need to? In my jurisdiction, they go to court approval if there is to be a settlement. So I have thrown out to you an idea about this professionalism, but I think this code really brings into play the real core issues that we need to address. But also I ask you to step back and consider some of these main factors, such as power imbalances that were brought up in the scenario that Dorcas has spoken to, the issues that Omer has raised, because the matters that really, I think in practice become particularly difficult is when people ask you to move out of your comfort zone and the role that you have contemplated you take on as a mediator. I think a lot of these things can be cured by clarity and by adhering to these codes. But what I'm not seeing in any jurisdiction at the moment is that mediators say they adhere to a code, here is a copy of it, or I attach it to the mediation agreement. And perhaps that's the next step. And perhaps the next step is moving closer to a profession for mediators. But if we are other professionals, then that interface is the difficulty that we're finding in Australia at the moment, is between expectations as a lawyer and whether mediation is defined as part of barristers' or solicitors' work or not. And I think that we need to look at those interfaces to make our practices work. So I brought in a slightly different perspective, and I'll leave it open for others to comment.
Thank you, Mary. You've given us a lot to reflect on. I don't know how much flexibility we have in terms of taking Q&A. We're at the bottom of the hour, so I defer to the conference organizers to perhaps let us know if we have a few minutes of flexibility to take a couple of questions. But I would also just urge everyone to take a look at the IMI document. And a link has been provided in the chat box. You can find the draft code on the IMI website. And yeah, I think Mary's remarks very helpfully captured just how complex and ongoing this conversation is. There are new issues arising all the time, whether they emerge from technology, right? We're beginning to think now about the implications of, for instance, artificial intelligence on the mediation process, third-party funding, the professional status of mediators, etc. And there are lots of documents out there, and there will be more. But you know, the IMI guidelines, which emerged out of a good, solid, 3 to 4 year process of deliberation, I think really represent an attempt to capture, in a manner that was detailed but balanced, the best insights from different jurisdictions and different codes, and to bring it together as both a document that can be used, of course, in a concrete sense to regulate mediator conduct, but also as a prompt to the conversations that we're having today. So it is 2:30. I'm happy to, let's see. Okay, so we okay. So I'm told we do have some extra time to work with. So unless my colleagues, but maybe before we open things up, I'll simply ask if Tat, Omer, Mary, Dorcas, if you have any additional things you would like to say that you didn't have a chance to, or final comments to add, and then saving that, we'll move to some engagement with the audience. But do any of my colleagues wish to get any other thoughts on the table before we move forward?
Well, I would like just to add, I think that Zach, you summarized I think our purpose and the gist of this panel very well. I would just add that we do want this code of ethics to serve as a practical guide for mediators. We want mediators to use it as a document, to consult it, to make it a living document, not just, ethics is not something which is shelved, which is put in a drawer. It's something that you can use. And although, and I think that our discussion here also tried to show that maybe there are not necessarily right answers or one right answer to a scenario or to a situation, but ethical questions, like legal questions, can be interpreted in different ways. But the important thing, and that is what we've tried to do in the Code of Ethics, is to set up the principles that can be used by the mediators, and to allow them and help them to ground their decisions in these principles. And if you arrive to one answer or another is less important. What is important is whether you can justify it by using these principles. And as we said, we try to explain these principles, not leave them as abstract principles, right? That we attach to them specific meanings in order to give more meat for the mediators so they can understand what they are expected to do. So I stop here, and please, Zach, take back the floor. And if there are questions, I'm sure that we'll be very happy to take them.
Zach, I think someone has raised a question in the chat. Is it?
Yeah, there was There
Please
was an
hand-
earlier question, which I think you, Dorcas, began to, you typed something of a response. It was a question from Dimitro. Let me just,
I think
has
the
there been
latest
a new
one.
one?
Yeah.
I'm
see.
wondering, the best
Niska.
thing might be, well, let me ask the translator what the best way to do this would be. Should we have questions addressed through audio so the translator can handle them? That might be safer than trying to do this exclusively through the chat box. I welcome people to put questions in the chat box, but I think also for translation issues, especially if you would like to ask in Ukrainian, maybe a hands up or some notice in the chat box can alert us, and we'll give you the floor. But why don't we move then to a time of Q&A and conversation? I just want to take a moment quickly to introduce as well my colleague Indrė Korsakovienė, who is also a mediator and a university lecturer. She's going to be joining the conversation now and being involved in the Q&A. So Indrė, welcome. Let's begin then.
Yeah, so I think that we before moving to the hands, maybe we could address the first question we actually had in our chat box. And thank you for Dorcas. She already has started to answer it, but I suppose it's very interesting because it provides very different angles and colors mediators are facing in the mediation. So maybe it's worth to voice it up, and maybe Dorcas, you could just continue to maybe slightly comment it if you agree with that. So we had a question from Dmitry Sarian, and he was maybe referring to the issues Zach was when he speak about neutrality and partiality, that if we approach the relationship between mediator and the conflicting parties from equal, close, and impartial standpoint, is it a good option? So maybe Dorcas, you could quickly comment on your message and maybe add some points here, which I think it's important for all.
Sure. Yeah. So I see Tat also has commented. So I'll just summarize. I think I just thought Dimitro made a good suggestion, because sometimes impartiality is understood in terms of being equal to each party or helping each party equally, right? What we have earlier stressed in the code of ethics, actually, the absence of or appearance of favoritism or bias. So I suppose that is one way of actually trying to remind ourselves, because if we treat each party equally, naturally that will avoid the appearance of favoritism. But there is a challenge of what to do when there is an imbalance of powers, whether that be due to information asymmetry, like the scenario we just given, or sometimes maybe other kind of issues, right? It could be also power imbalances. One side feels more intimidated than the others. So I think Tat has helpfully reminded us that sometimes what we perceive as imbalanced resources might not be a huge barrier to creating a safe environment or fair environment, as Omer suggested. So I think a lot of times some of these things can be, like Mary suggested, can be avoided by before the mediation also having a conversation, so that then they can be assessed more accurately as to whether there are imbalances, and if so, those imbalances, are they severe impediments? And more importantly, if there are imbalances, what can be done prior to the mediation, rather than we wait later and then we discover this, we have to postpone, right? So some things can be done sometimes in terms of bringing a support person, getting more advice, setting a later date. And I think what Dimitro has suggested and Omer has suggested as well is, during the mediation, if it's really a very bad impediment, as if we suspect one party is not ready to decide in an informed way, sometimes you might need to postpone so they can seek some other advice. And even if they reach an agreement, I think Mary suggested sometimes it's good to have cooling off period. That means after the agreement is not finalized until a certain period, right? So just in case some people might need to check. So I think that summarizes some of the comments.
Yes, thank you, Dorcas. Thank you for your answer. And I think we can move to the hands. I see the raised hand, and I'm sorry if I will misspell the name because it's really difficult to work in this multicultural environment, and sometimes we do have challenges to spell the names. But I think that Desire, you would like to ask questions, so maybe you could introduce where are you from and ask your question to the presenters.
Yes, thank you very much. My name is Morima Desire, a Burundian refugee lawyer and mediator for my legal initiative Jime Pro Justice by Mediation program in Rwanda. I have studied law in Rwanda because I fled Burundi after political conflict in Burundi from 2015. So my question about to this topic, mediation and the law, I want to ask how this mediation and the law can be implemented in refugee camps worldwide, in Poland, in Europe, in East Africa, just to strengthen good cohabitation in refugees, because refugees have different cultures, just to avoid judicial procedure. Because when you go to court, it is very expensive for poorer persons and for specifically for refugees. How to work just to build mediation, to rebuild good cohabitation between refugees in refugee camps in different countries. Thank you very much.
Is there any specific member you would like to answer to your question, or? Well, I think we can invite, I don't know, maybe first of all, I'm referring to your question about the refugees and mediation. I recently participated in one of the trainings, actually, and we had a distinguished trainer from Germany, and she was sharing how actually mediation was adopted as a very useful tool to actually manage the conflicts between many refugees and many different people coming to Germany. And of course, you know, having this multicultural environment, it usually happens that there are different conflicts between those members and between them and many institutions involved. So definitely here, I think that probably all of our members would agree that mediation and dealing all these conflicts with the refugee issues is really suitable. But once we talk about ethics and mediation today, I don't know, maybe Omer, Zachary, or Dorcas, you would like to add here to this question.
Well, I can. Yes, please, Mary, please.
I am a daughter of a political refugee, and I have mediated in that area. And I think the idea of cultural awareness and equity and equality in how the dialogue is developed, and it's usually multi-party, that it's really suitable to allow for outcomes. One of the difficulties is often states are involved and they have parameters about their own decision-making and policies, so that can also bring in an additional feature that can be more difficult to manage than otherwise. But I've seen it amongst those who are within the refugee camps, as well as issues arising with the state to try and give pathways out, and also condition issues or whatever that might be. So I have seen it used in a broad spectrum of matters in that space, and I think it can be highly useful.
Yes, thank you, Mary. And I would like to add that it's also this idea of talking about refugees and mediation between incoming people into a receiving country is obviously very much relevant to our discussions of ethical issues, right? It's even more important then to look at the ethical principles and see how they apply in these situations. because what you are describing here is obviously a situation which is on the surface creating imbalance of powers, right? I mean, the persons who come over to a new country come with less knowledge, with more difficulty with respect to means of payment, even the language. So issues of party capacity, for example, the ability to participate, and how do you create conditions in which they can participate effectively, the involvement of translation, the involvement of some support, basic knowledge about the law that applies in this situation. So there are plenty of issues of ethical aspects that needs to be taken care of. And again, I think it is highly relevant and to engage in this ethical discussion. And when there are trainings which are given to these interveners, these mediators in such as they require that ethical layer of training as well, which is quite important.
Thank you, Omer. Would any of our IMI members would like to add something here? Okay, so maybe we can have some more questions. Anyone? If you just could raise your hand or maybe text in the text box. And as Dorcas has mentioned previously, and I was texting again in the chat box, I'm sure that, and I hope that some of you will really spend some time and read our drafted code. And if you will have any comments regarding it or any questions, you are really welcome to add all those comments and share it with us, because it's only, some of the stage preparing the final draft code. And as Mary mentioned, the committee itself contains of representatives of different jurisdictions, different experience, and different people. So what we expect and what would be very helpful for all the committee is getting the insights about the code and how are you reading those provisions, suggestions maybe to say, and how do you address them. And we have one more question. I see Malika, please, if you could join us and just simply say where are you from and ask your questions for our members.
Good evening, everyone. My name is Malika. I'm from Uzbekistan, Central Asian country. I am a recent graduate of the law faculty in Tashkent. And my question is about the current economic uncertainties and the problems with multinational corporations and the states in terms of the following the ecological sustainability and natural resources problems. So could you please suggest how can mediation effectively be utilized to ensure there are no tensions in terms of the ecology? Because my work at the UNDP directly concerns the problems of the ecology and the state concerns.
Thank you. That's an interesting question. Please, our members who would like to address it.
I'm happy to, if that's okay.
Sure.
I think I work in the area of environmental and ecology and the broader perspective of that, but it also brings in two issues. One, public participation, and the other is the public interest. And I think the ideas that are in this code about being impartial become really important. Independence of the mediator and dealing with everybody equitably. And confidentiality is very difficult in these circumstances because they're obviously in a broad canvas and often the state's involved and sometimes the media. So often there needs to be a consensus about the process and bringing to bear all of these issues so that everybody feels that they have a voice and a say in what the outcomes are. And my experience is that often the outcomes found in these sorts of multi-party, broad perspective, value-laden disputes are not necessarily the ones you're going to find in a court-based system. And so I think there is great opportunity.
Thank you, Mary. And I think Tat has switched on the microphone. Would you like to add something?
Well, I would add that, I mean, the codes, I think, provide a framework for one to consider steps to move forward when you think about ESG disputes. In some of the work that some of us do in the space of World Bank's involvement in funding developments in third world countries, those issues are live. And they often affect communities who may not have resources to to articulate their concerns to the relevant authorities, and that's where a mediator can come in and provide that level playing field for those concerns to be articulated according to the concepts of the ethical concerns that, standards that we've been talking about this evening. And take, for example, the question of ecological concerns. One method that's proven very helpful is to have joint fact-finding. But that itself has its roots in the question, based on the issue of fairness in the process, fairness in the dispute, in the mediation process, and all those things that we've been talking about will come live when you think about how the mediation can proceed based on these ethical principles. So, that's something I think is worth thinking about. Indrė, you're muted.
Yeah.
Oh, I'm sorry. Thank you, Tat. And I think we have one more question from Vesna. Please, the floor is yours.
Thank you very much. Good afternoon, everyone. My name is Vesna. I come from North Macedonia, from the beautiful city of Ohrid. A very joyful city in this time of the year because it's the major touristic center in Macedonia. Having in mind the fact that I work as a youth worker, I would like to ask something related to that issue, and I hope that I will be granted with an appropriate answer. Namely, can any one of you explain to me how can we apply the mediation in law in terms of youth organization, youth laws, and implementing youth policies? Thank you very much.
Thank you. Thank you, and welcome from Moldova. It's nice to see different people from different regions. Omer, would you like to take this question?
I'm not sure that I think that in ethics, one of the things that we need to be is transparent in our capacity and competence. So I must confess that I don't have enough knowledge about this particular aspect of mediation. So I'll defer, maybe suggest that maybe one of the other friends will offer some comment.
Is it all right if I clarify?
Yeah,
Is it
go
all
ahead,
right?
Dorcas.
I'll clarify with Vesna. Vesna, just want to understand better. What kind of issues or youth issues are you thinking of when you talk about mediation that can cover youth issues? Is there anything you have in mind, Vesna, in particular?
Maybe you could just provide, I don't know, some example which would be more helpful for us to understand. Is it like your question more about general? Is it the young generation are can gain those skills as a mediators and use them themselves, or they are as a mediation parties could engage into the mediation? So if you could just provide a little more context for us to understand your question better.
Yes, thank you very much, and I'm sorry if I wasn't clear enough. I'm working with young people deriving from different and mainly vulnerable ethnic and social communities. They are still highly unaccepted in the society, especially girls. Unfortunately, that's the system still here. Because most of them have parents who are stuck in the 19th century, literally with their thoughts and attitudes that girls shouldn't go to school. And my question was, how should we act in that case to convince the parents, to convince the schools that it's very important to implement that kind of social politics? How to be a mediator between the schools and the families?
Yes,
Thank you very much. Sorry if I wasn't clear enough at the beginning.
Right. Well, that makes it a little bit more clearer, as you say, and I think that one of the issues that you raise here is maybe regarding the role of mediation and of mediator. And I think that sometimes we use the term also cultural mediator, right? A mediator who mediates between people of different cultures. But I think it's important to note here, for example, from your question, it seems that if the mediator, in this case, if we call him mediator, there's a kind of a role of convincing one of the parties to do something, right? Which is more of, I would say, of maybe, I would not use the term mediator in this case unless it means to mediate between different cultures, to explain to one, for example, to someone who is a client of the system, right? To those families, to those, what are the norms, what are the expectations in our community, which might be different from the community from which they arrive. So, as I say, sometimes this comes under the label of cultural mediation, or it is a cultural mediator. But I would not see that as a mediation in the sense that we have been discussed here, a mediation between two people or two groups or two that you are trying to bring them into an agreement, and more kind of you are on a mission to explain something. That having said that, I'm not saying that there won't be or there can't be a mediation, a kind of a more original, let's say, or a mediation in a classic sense. Of course, there may be, right? But the mediator in this case, for example, let's say that the child doesn't want to go or want to go to the school, and the parents do not wish him to go to school. And then the mediator in this case can actually be involved in a mediation between the parents and the child, or between the parents who do not wish to send their child and the authorities or the school. But then the mediator, it's very important. And we talked about that when we discussed the principle of professional integrity. It's very important that the mediator has his independence, right? He is not actually the representative of the school. He is not representative in the sense that he has a stake, he has the mission, but he's there in order to facilitate the discussion between them, make them have all the information and help them make a decision, right? But he is remaining in a way, right, this neutrality in the sense of impartiality or independence that we've discussed earlier. So I hope that it answers at least some of your question.
Can I just add something which is a little different? I think in Australia, we actually trained the youth. We trained students at school. So we trained them with skills in mediation so that they could develop dialogue and that they were able to engage in a method that would empower them. But also within the schools, other students and teachers were trained so that they were able to have the skills to assist. So you can do pilots, small pilots, but we started this probably way back in the early 90s, about 1993. And then they had, school competitions and so forth. But teaching the skills often empowers people to be able to bridge the gap and to have understanding across cultures. And those vulnerable youth are able to hopefully progress and engage over time. It's not a quick fix, but it's something else that can be engaged.
Thank you, Mary, for adding this. Actually, this is what my experience tells when you're working with the young people, young generation, and all those pilot projects and some kind of peer mediation projects. When you educate those young people, one of the advantage of that is that they became familiar with the method as mediation, yes? But another aspect, which is maybe even more important, that they start to gain those small steps, small tools, and apply them in their daily life. They are more able to express their opinion, their emotions, their concerns. And feeling this, the method of mediation becomes more and more close to them. So sometimes you don't need to convince anyone to engage into mediation, but they just come into the mediation voluntary. And that's when we talk about party self-determination, which is really crucial when we talk about the mediation process. So as Mary mentioned, there are some small steps. Maybe there are issues when you cannot change in one night that somebody will come to the mediation table, but still some steps. It's worth to start to do them within the society and actually see how the changes slightly appear within this. So hopefully we could address your question. And we have one more hand. Malika, do you have another question? Because we still have, I don't know, maybe 1 minute to answer it, or it's just the hand from the previous time.
I have another question, if you don't mind. I'm doing my dissertation in international law and more specifically in territorial conflicts, cross-border conflicts. And I wanted to ask a question about the mediation, the role of mediation in resolving the territorial conflicts, because mostly mediation, as I know, is used in rather more official commercial conflicts, but not the ones that are like the cross-border ones. So could you please tell anything about this?
Okay. Yes. Who would like to take this question? Dorcas, maybe, yeah?
Is it about cross-border mediation, right, Malika? That's what you're interested in. Yeah, I think most of us in the committee, we actually are involved. We have done that, cross-border kinds of mediation. And in fact, I think we are aware that Ukraine is a party to the Singapore Convention on Mediation. So that convention, it was actually meant to make it easier to have cross-border mediations, although the scope of that convention is purely for international commercial disputes. But it just means that countries, including Ukraine, that have signed and ratified, it means that they agree if there's an agreement arising for cross-border commercial mediation, and someone wants to enforce in the country that has signed that convention agrees to let it be enforced. But definitely cross-border mediation, I think that's one of the best ways in which disputes can be resolved, because you avoid a lot of complexities. If you were to use some of the methods, say like legal methods, there are a lot of barriers you have to cross. The challenge really then is choosing the appropriate mediator who can be trusted by both sides and who also has cultural intelligence and awareness, so as to know how to adapt a lot of these things. I think there's an earlier question as to whether I might quote into account culture. And the very fact that it's a diverse group in the committee, I think shows you that we had lots of debates in terms of how we look at it from different cultures. Yeah, so cross-border disputes is really a rich source, rich context to exercise that kind of cultural awareness. Yeah, but feel free to add any other colleagues in terms of cross-border disputes.
Yes. So thank you, Dorcas. And dear Louisa, if we are just, being too much with our time, just let us know if we have, I don't know, one more question to answer, because I see the hand of Corina maybe. So if we would be very, very short, please raise your question for our members.
У вас є час. Якщо
You still have time if you want to. Please go ahead.
Thank
We
you.
did know the topic would be very interesting, and there are so many nice speakers. That's why we wanted to take advantage of this longer time to be able to answer more questions, please.
Thank you, dear Lisa. And I see that our members also sharing so many links, interesting and very useful in our chat box, so you can just follow the conversations there. And I think it was Corina you who was raising the hand. Do we have you? Yes. Hello.
Hello, everyone. My name is Corina Zavtonia. I'm from Chisinau City Hall, from the Right Protection Department. Children Right Protection Department, from one of the district of Chisinau. In addition to the question of one of my colleagues from Republic of Moldova, I would like to ask you what principles of meditation we can apply in order to mediate parents and the youth and children in order to in one of their conflicts that appear, for example, to go to the school, or maybe to take care of themselves as a person, because very often it happens that they have some conflicts, and we as Children Right Protection Directorate were obliged to help them to solve this problem. Maybe some of your speakers can help us, can give us some advices.
Thank you again for your question. I see that the issues between the young people and the problems and maybe conflicts they're raising and they're experiencing is really very important for you and within the country. But I think it's not only about Moldova. I think it's the same we have in our schools in Lithuania, for example, and we are now participating in an international project with the Ukraine, Georgia, Netherlands, and actually all of the participants and the representatives from universities, from schools, were raising more or less the same question. So how to use mediation to be able to help those people or maybe get closer to them. So again, maybe we're coming to the same to the very close answers we had provided previously, that the peer mediation and mediation as a method is really empowering people. So first of all, just I really invite you to get more familiar with the mediation and the methods the mediators are using yourselves. And that's about asking questions, about active listening, about many other tools that mediators use themselves to actually understand the problem. Because I think the first thing when you think that you want to help is you need to understand. So what is the problem of those young people? Maybe some of other colleagues would like to add here something and answer this question.
Could I add that I think one thing to bear in mind is also that there are complex issues and not every issue might be suitable for mediation. So one thing that does, I might not understand your context, but one thing that did strike me is that if the dispute is between, say, children, parents, schools, usually when you convene mediation, right, the assumption is that each party has capacity to make decisions, right? So some things that does alert me when there are children involved, right? We have to be quite careful also to then consider, right? So if they have a dispute with their parents and it sounds like because these disputes they're asking a certain authority to resolve it, right? But the first question is whether mediation is most appropriate mode to resolve the dispute, because for it to work well, it means that the solution must be something agreed by everyone who has capacity to decide for their interests, right? So it might mean that there might be some, if they need some other person to be their support person, their spokesperson, you might need things like that. I say that because I've been exposed to some mediations where it involve families. So when it does involve people of different capacities, we have to be quite careful as to how we deal with that. So that's just something I like to point out.
Thank you, Dorcas. And I think that really we are so thrilled about so many questions from you, and hopefully we could answer at least a little bit. And it's very nice and pleasant to see the interest of all of participants about our presenters. But I think anyway, first things comes first. So all of the participants need to have a break, which is actually planned, to drink water, to have a rest a little bit. And I'm sure that this is not the last time we're participating with your organization within your events, and hopefully we'll be able to address many, many more issues and answers lately. So just we want to thank you for inviting us to be here. And we had a pleasure to participate, to open your great and huge event, and wishing you the best of success in the rest of the day, and I think 2 more days. I know that you have a great and very extended list of panelists, so just great wishes to have an insightful event for all those 3 days.
Thank you ever so much. This was an incredible discussion. We want to thank all the speakers on behalf of the Ukrainian Mediation Academy. We would like to express our words of sincere gratitude to all the participants who have joined us already and who will be joining us later during the days. I understand not everybody can be here with us from Ukraine because of the electricity constraints, and the topics are so important. We've been facing those issues so many times and so frequently, and we as mediators normally face dilemmas and problems of choice primarily. Similarly, we have sometimes misunderstanding with the other professionals who do not quite understand what mediation is all about. We have to be proving every time. This is something that we feel there is need to put this message across. We need to build more understanding and awareness of our profession, but not always this works so far, but we're trying hard. Thanks very much for everything that you've done on an international level to actually develop the code, to build proper understanding of what mediation is and what it isn't. Of course, this is one of the pillars, and this is also a great commitment. I think mediation should remain to be a flexible and adaptable tool to resolve disputes. Thank you. I don't have enough words to express it, but I'm so grateful, like, once again. I would like to invite everybody to continue your participation in the forum. We have 3 more days to go. Not even 2, and we continue to work on Saturday. We're going to be drawing on Saturday. There's going to be very interesting master classes, so please stay with us. Right now, we're going to have a short break for just 20 minutes, and then afterwards, we're going to continue with the presentation of our manual. We're going to have not just speakers, but co-authors of this mediation manual that we're going to introduce today. And in the evening, we're going to have another networking on a different platform, not soon. We're going to have even a cake that we cooked and some beverages as well. So you can virtually enjoy that with us. Thank you so much, and see you in 20.